If you asked most Americans to name one of the cornerstones of the U.S. Constitution, many are likely to respond, well, freedom of speech. And it's easy to take for granted that we can say nearly anything we want without fear of legal repercussions, but that wasn't always the case. As late as the 20th century, freedom of speech hadn't been fully realized, and judges commonly ruled that the government could censor and even imprison those that spoke out, especially in times of war. That is, until one Supreme Court justice stood in defense of a broad interpretation of the First Amendment. His landmark dissent, not majority decision, dissent, paved the way for the freedom of speech we enjoy today, and it's the topic of today's Real History.
Oliver Wendell Holmes is widely regarded as the greatest judge in American history. He fought in the Civil War, was wounded 3 times. He came from a famous Boston family that was part of the intellectual aristocracy of New England. He was appointed in 1902 by Theodore Roosevelt, who had a very progressive agenda and thought that Holmes would be sympathetic to that agenda. It turned out that Holmes disappointed him. When the administration brought an antitrust action against the railroad monopoly, Holmes actually ruled against them. So he and Roosevelt were quite good friends at first, but the relationship cooled after that decision. One thing you have to understand is that prior to the 20th century, free speech in the United States was largely an unfulfilled promise. So there were a series of cases that came before the court, all of them arising from the Espionage and Sedition Acts. The Espionage and Sedition Acts prohibited individuals from obstructing the draft, from inciting disloyalty in the military. They also, especially the Sedition Act, basically prohibited any sort of criticism of the government. 2,000 people were prosecuted under both the Espionage and Sedition Acts, and people began to challenge these convictions. At the very beginning of 1919, the court heard 3 challenges to the Espionage Act. And in those cases, the court upheld the convictions. And the justice who wrote those opinions was none other than Oliver Wendell Holmes. Holmes had done as much as any judge to render the First Amendment toothless. He had embraced a cramped English view of free speech. So after those 3 cases, the court in the fall of 1919 heard an additional challenge to the Espionage and Sedition Acts. This challenge was brought by Russian anarchists who had come to the United States and opposed the war, but what they really opposed was President Wilson's intervention in the Russian Revolution. And they printed flyers that they circulated in New York City, encouraging workers in the munitions factories to go on strike. They were arrested and prosecuted. The name of the case is Abrams versus United States. So a majority of the court in the Abrams case ruled that the conviction should stand, relying upon the opinions that Holmes had written earlier in the year. Holmes, however, dissented. He objected on a number of grounds, but more importantly, Holmes, for the first time, expounded a theory of free speech. What Holmes basically said is that persecution for the expression of opinions that you disagree with is perfectly logical. However, he then relied upon the notion of experience, and he said that the best test of truth is the power of the thought to get itself accepted in the competition of the market. And this idea that it's in the competition of the market, the marketplace of ideas, that's where we'll find truth, that has its roots in Holmes's opinion. It's completely contrary to everything Holmes had said before. So why did he do it? And it's something that historians and legal scholars have wondered for a century. And the answer is there was this very intense behind-the-scenes campaign by a group of young progressives who Holmes was friends with, who were trying to change his mind. So during this time frame, Holmes is near the end of his career. He is 78 years old. For the most part, he is a little disappointed. He has always wanted to be regarded as the greatest jurist in the world, and he hasn't quite reached that point. So just at this time, when Holmes is sort of worried that he's not going to get the recognition that he wants and desires, this young group of intellectuals are starting to give him just that. He met them in Washington, D.C. at a house in DuPont Circle that was known as the House of Truth. It was a gathering spot for young intellectuals and lawyers and diplomats in the capital, people like Harold Laski, who at the time was a young instructor in history at Harvard, went on to be the leader of the Labor Party in England. Felix Frankfurter, a rising young legal scholar at Harvard Law School, goes on to be a justice on the Supreme Court. Walter Lippmann, a well-regarded journalist at the New Republic magazine. These men would come over to Holmes's house for tea, and they would sort of sit at his feet and listen to his stories and his anecdotes about the law. And he views a lot of these young men, particularly Harold Laski and Felix Frankfurter, as almost surrogate sons. Holmes and his wife Fanny never had any children, and by the end of his life, it was a source of disappointment to him. So gradually, these men became a very important part of Holmes's life. This is all happening in 1919 during the first Red Scare, when people were gripped by a sort of panic, a frenzy about the rise of communism in Russia. Felix Frankfurter was a big proponent of labor at the time. Harold Laski was basically viewed as a sort of Trotsky in the United States. These young men were very much under attack during 1919 for their views. And friendship with Holmes, for them, was legitimacy. And so when Holmes wrote his dissent, in a way he was standing up for his friends. The fact that a justice of the Supreme Court could be influenced by such personal considerations, I think is quite incredible. We talk today about judges or justices changing their minds occasionally. This, Holmes's change of mind, is the most important and consequential change of mind, I think, in American legal history, because what it does is it basically ushers in the modern era of free speech that we know today.